Good afternoon. Welcome everybody to the webinar. It's another webinar on the Psychology of Claims series, where we've been understanding human behaviour and challenged by adversity in the delivery of engineering construction projects. We've run a series of 5 webinars which have now concluded. We've done those over the last few months, and we've covered several topics. We've covered fact, fiction and claims. We've covered delay liquidated damages and extensions of time. We've covered preparing for delay analysis, value, cost and damages, and the effective use of ADR. And for that series, as today, I'm joined by John Fotherby, who's a partner at Kingsfield Academy. I'm Alex Johnson. I'm a partner with Freeths. I'm an engineering construction lawyer. And we also have Wayne in the background who will filter through any questions that you may send in. Now, we covered a load of content over the course of these 5 webinars, and we had a great response from all of you and from others who joined us. And we thought what we should really do is try to answer your questions. So this webinar is primarily a Q&A session, and many thanks to those of you who've already sent in questions in advance. We have had a chance to read those. Thank you very much. You've also sent some of your experiences based on real life issues that you're facing on your projects, which have been triggered by what we've said on our webinars previously. The good news for everybody else, you are not too late. So please today, more so than ever, ask us questions and give us your real life experiences that you wish to share. Now is the time to do that. This is a webinar devoted to your questions and hopefully our answers to them. So please feel free to ask the questions as we go. Send us comments or experiences. If we say something that you think, oh, I know something about that and I'd like to say it, please do. We would like to consider real issues in the context of what we've been discussing on our webinars. We've got 1 hour today. Whether we reach the full hour is really down to you and how many questions you ask. We've got plenty of time to answer questions. In the usual way, please note them down, submit them, and Wayne in the background will send them through to us. We will keep all questions confidential, and specific party and project names will not be referred to. So don't worry that any confidential points or names or anything like that will be discussed. We won't do that. If you haven't managed to join us for any of the previous webinars, they're all available online. You can access them on Kingsfield Academy's YouTube channel. And also, of course, if you have any questions after the webinar or any questions you'd like to discuss with us, just feel free to email us directly. One more piece of admin before we start. We've uploaded 2 documents which you can download today. They're in the handouts box on the webinar panel. One is a consolidated set of written answers to the questions that were submitted during the previous 5 webinars. Those of you who have joined us previously know that our track record of answering questions isn't great and we tend to run out of time. And the other document is our checklist of questions to consider before we embark on a scheduled delay analysis exercise, which we discussed during our 3rd webinar. So to commence, we received some questions. Thank you very much for those. One question in particular covered a series of issues that we thought would be a good place to start today, and to get you thinking about your own questions that you might wish to ask. So as we begin exploring this, do send in your questions and comments, and the quicker you do, the quicker we can start to answer them and have a more interactive session than we're usually able to. We noticed that we had a particularly strong response to the webinar on liquidated damages and extensions of time. This had by far the most YouTube views, so it's obviously a topic that's generating some interest. And we thought it's a good one to begin with. Either that or someone's using that one as a sleep aid, and in which case I don't blame them. So the question we received was this. There's quite a bit of detail in it, but I'll read the question out and then we'll break it down into smaller chunks. The question was, we have a lump sum EPC contract for an ammonia plant. It's governed by English law. We're about 70% complete overall, and this story has been going on for a while. We've requested an extension of time of 3 months due to force majeure, and the client is not giving us access to the site on the date indicated in our approved schedule. The client has refused to grant an extension of time because he says that we were already in delay with our engineering deliverables, and therefore there was no need for him to give us access to the site on the date in the schedule, and the force majeure event occurred after we were already in delay with our engineering deliverables and therefore had no impact. The client is insisting that we complete all of the work by the contract completion date. We put more effort into producing our engineering deliverables and had sufficient documents available to commence the work prior to the client giving us access to the site, which was 2 months later than the date on the schedule. The force majeure event commenced 4 weeks before the client gave us access to the site and ended 4 weeks after we were given access. And the force majeure event is described as a major flood which washed away the only bridge over which we could transport people, equipment and materials, and a temporary replacement had to be installed by the local road agency. The client's position seems very unfair to us and we've protested, but the client refuses to discuss the situation and the extension of time. And this leads to the questions: what is our contractual position and our rights, and what would you advise that we do? I think first of all, Wayne, we'll have a quick poll here just about whether you've encountered similar circumstances on your projects. And so that's requests for extensions of time that aren't being met, force majeure events and the impact of those, refusal in relation to access. We just wondered whether these are the types of issues that you're facing. So in the usual way, just please click on the panel, yes or no question, quite an easy one to begin with, and we'll see what the result is. We expect results quicker than the US election, I should say. There we go. 64%, okay, 2/3, that's good. So clearly this is picking up on a few issues. So I think to begin with, what I'd like to do is break this question down because there was a ton of detail in it, and this was one of the reasons why we picked it. Primarily, this concerns a request by the contractor for an extension of time. And there are 3 events that the question refers to that may, in principle, entitle the contractor to an extension of time. We have the force majeure event, which is a flood that washed away the access road. That's alleged by the contractor who is writing this question. There's refusal from the client to give access to the site on the day in the approved schedule. That's also been alleged by the contractor. And there's delay to the production of the engineering deliverables, which the question suggests has been alleged by the owner. But of course, that's only an extension of time if the owner is liable in some way for those engineering issues. So we seem to have a difference of opinion between the contractor and the owner, in that the contractor considers it's entitled to an extension of time, the owner doesn't. We've got some potential issues about which events are on the critical path and therefore whether the events cause critical delay. And we also have issues concerning potential concurrency of delay events, and that begs the question how the contract may treat those events. So legally speaking, from my point of view, I'd be looking for the following information from the contractor. First of all, what does the contract say about the events that entitle the contractor to an extension of time? What, if any, obligations does the contract place on the owner to give access to the site on the alleged date? And what does the contract say about the concurrency of delay events? So that's the legal perspective for now, and we'll get into each of those. John, what are your initial comments on the question, and is there anything that you would add to the issues breakdown from your technical perspective? John, you may be on mute.
Some builders outside making a hell of a row, and I tried to avoid them. Sorry. So I'll repeat myself for the benefit of everybody else, apart from me. I think that we have to consider this situation from 2 perspectives: contractor perspective and owner perspective. Because there's sort of a pivotal situation here about whether there's any responsibility and liability for granting extensions of time, and possibly even costs that might arise as well. But let's deal with the EOT first. So I think the first thing is and it's in both parties' interest to actually know what the facts are here, what is real. So for me, the starting point is the engineering deliverables and why were these late? And we'll come on to the reasons for this a little bit later. But that's one of the areas where I'd want to inquire. I think the force majeure event in itself would be quite obvious because, you know, there's been a storm or something, the bridge has disappeared, so it'd be pretty clear what the situation is. And the non-access to the site is pretty obvious because you can't get on the site. But the engineering is less clear. What actually happened there? What was delaying deliverables? What action did the contractor take? He says he put some extra effort in and brought the deliverables up, but there's some inquiry to be made there. And I'll go into that in a little bit more detail in due course. And then I think the other point that is really crucial here is that there is clearly some sort of delay. The full extent of that we don't really know at the moment, critical delay that you mentioned, Alex. But clearly there is some delay and the owner is refusing to grant an extension of time. Now that puts the contractor into a bit of a dilemma. It's quite early in the job. There may be the opportunity to recover this, but once the contractor does, he's taking on the risk of achieving that completion when probably in principle he is entitled to some extension of time and an adjustment to the completion dates. So as soon as a contractor embarks upon that route of trying to overcome what is in effect an owner's delay, then he's stepping out into the unknown basically and starting to bear costs and some liability there. So making a decision about what to do here and how to handle it is really quite important, because if there is a critical delay, then the completion date won't be valid anymore. And that then has an effect on the remainder of the job in terms of progress measurement, etc. And any other delays that might occur, because, you know, we're very early on in the job. So making a decision about what to do about this is really quite important. And that's an area that I'd be wanting to look at to see, is there really a delay here and how much is it? So, Alex, we're thinking about that. What's your view on the contractor's position under the contract, and what's his rights likely to be?
Yeah, thanks, John. I mean, we've obviously not seen this particular contract, so the answer is given in terms of general principles and the way that contracts would usually handle these kind of issues. Well, I should say the answer to this question, if anyone is sort of interested in the question itself, and you know, by all means ask your questions right now if you'd like to. The question covers a lot of the material from webinar 2 in particular, where we discuss liquidated damages and extensions of time. So that's a good thing to fall back on if you're interested. But let's consider the events that cause delay that are referred to in the question and what the contractual effect of those events is likely to be. Force majeure, let's deal with that first. Force majeure has been a real issue in 2020, primarily because of the pandemic. I mean, nobody talked about force majeure in my experience very much at all until this year. And I think the only reason everyone started to talk about it this year was because it seemed the logical contractual position for the effects of the pandemic, given that most contracts don't specifically deal with pandemics or don't specifically deal with the effects of pandemics. It's safe to say that most contracts entered into after March now do deal with the effects of this particular pandemic, if not in general. But let's go back to basics on force majeure. Force majeure is essentially the occurrence of an event that neither party could have provided for at the time of entering into the contract, and which affects the ability of either one or both of the parties to comply with their obligations. So it's primarily an unforeseeable event, and it affects parties' ability to perform. The establishment of a force majeure event typically relieves either one or both of the parties from performing their obligations. So the contractor is relieved from the obligation to carry out the work. Essentially, in this case, is where that's relevant. Force majeure events typically entitle the contractor to an extension of time, but not additional payment. This was another point that came out of the pandemic in terms of how a contractor may recoup its costs, and the answer is not through the force majeure clause typically, unless the contract says something different. So in this case, on the assumption that the major flood was caused by a natural catastrophe, and it seems that would be the case unless the contractor caused it, which there's nothing in the question to suggest happened, then the destruction of the bridge or the access road is probably a force majeure event. Natural disasters commonly being force majeure, and flood typically is. And as the bridge was the only physical access to the site, it's clear that the contractor is unable to perform its obligations, and it's very likely to be unable to mitigate without there being a new access created, which is what ultimately happened. Let's look at the second one, which is the refusal by the client to give access. Now, there's likely to be an obligation on the owner in the contract to allow the contractor access to the site from a particular date for the purposes of carrying out the works. A contractor under an engineering construction contract is typically obliged to carry out the works and entitled to carry out the works as well. So they are given possession of the site for this purpose. A failure to give access is therefore a failure to give possession, and that prevents the contractor from fulfilling its obligations and from exercising its rights. So the refusal to allow access, in the absence of any agreement with the contractor to defer access, is primarily a breach of contract and also an act of prevention by the owner. And typically a contractor will be entitled to extension of time and probably also to additional payment in such a case. The contractor is also, going back to something we mentioned in the previous webinars, entitled to claim damages for breach of contract, because remember, this gives rise to two claims. One is a claim under the contract, one is the claim for breach of contract. It's probably more likely that the claim will be made under the contract because it has the specific rights to time and money, we would think. And that was webinar 4 where we discussed some of those issues. So, final issue, the delay to the production of the engineering deliverables. Well, unless the owner has some way intervened, typically that's the contractor's scope of work, and a delay in producing them in those deliverables will be the contractor's delay. Now, that's sometimes referred to as culpable delay, i.e. it's delay caused by the contractor in relation to which an extension of time is not available. That position could change if the owner was required to provide something that the contractor needed in order to produce the deliverables. So checking for obligations on the owner's behalf would be important here to understand whether this was a contractor fault event or not. Now, if this event caused delay, it seems the contractor made some attempt to mitigate or recover the delay because it claims to have been in the position that it had sufficient documents available to allow it to commence the work in any event. So in relation to those events, I think if the contractor is correct about the status of the engineering deliverables, and if the contractor was in the position to start on the site, then the employer's obligation to grant access is not rendered invalid simply because not all of the contractor's engineering deliverables were in place. The owner still had the obligation to allow access, and if the contractor was ready, then the delay, if the contractor was not ready, the delay is the contractor's. Because the owner denied the access, even if the contractor was ready in terms of engineering deliverables, then it couldn't have accessed the site if the owner had prevented it. But the complicating factor in all of this is the force majeure event. It seems to me that the owner would be given relief from its obligations under the contract, including the obligation to grant access, if there was no access available to grant. So I think what's important is, depending on the precise timings of these events, it could be that the force majeure event drove the critical delay rather than the refusal to give access or the lack of the engineering documentation. You're almost trying to stack these issues up and work out which one dominates the others. So it seems in terms of entitlement, it's clear that the contractor will probably receive extension of time, principally by virtue of the force majeure event. As we discussed in the second webinar, the general position under the law, if the contract doesn't say anything to the contrary, is that the contractor gets the benefit, i.e. receives an extension of time for concurrency between delaying events for which the contractor is responsible and delaying events in respect of which the contractor may be entitled to an extension of time. So the extent to which the contractor, for time, I think is quite clear. The extent to which the contractor is able to claim additional payment depends on whether any delay was in fact caused by the refusal of the owner to allow access, and whether the contractor should have commenced work but for your owner's refusal. So the possible impact of the force majeure event on this question is is quite important to establish, and also just sort of put the marker down, as we've mentioned in previous webinars. Remember that the time and money claims are separate and they must be claimed separately. So here it seems time is fairly straightforward, but money seems to be a bit more complicated. So with that in mind, John, what information would you look for from the contractor to try and unravel the factual position and establish that it's entitled to an extension of time?
Yeah, I think you made an important point, Alex, that there's this overlap of these events, and therefore what is really dominant here, what is driving the ultimate delay, and are there costs associated with that that are recoverable under the contract? So I think for me, the first thing is to have a timeline of events starting before and going beyond this period over which these events occur. And I don't mean a schedule analysis, I mean just a timeline. What was occurring when and what should have occurred when? And let's just see what that picture looks like. Because I think one of the key issues, and you were talking about whether the contractor was prevented or not. I think a lot of people make the mistake of just playing with the two events, the force majeure and the the prevention of access to the site, and playing with those on a schedule analysis to see what can be produced by P6. Whereas the fundamental for me is, was the contractor ready or not to do the work? And therefore the first question is, did he have what work fronts did he plan to have? Did he have the engineering deliverables available to be able to commence and proceed with that work front or those work fronts? And that's basically a yes or no question, depending on what deliverables he did have available. Now, on the face of it, according to the question, he had prepared sufficient documents to get started. Then the question comes, how could he service the rest of the work fronts in theory? Because by the time you got the prevention of getting onto site and you got the force majeure, we're then saying, well, he should have been building up then to have more deliverables available. So he could have been able to start at any time were it not for the two events for which an entitlement to extension of time is due, and then we have this prevention issue of getting onto the site. So I think then the question is, okay, you got the deliverables, and that may be engineering deliverables, it may be materials, it may be equipment, it may be construction equipment, and so on. But then we come to the contractor's manpower. Did it have the site set up to accommodate the manpower? Did it have the manpower available to deploy? If this, was really getting off the ground, and it seems to be a sizable project, then the planning for deployment of those resources must have been well in hand. So what happened to those resources when you couldn't get on site, and then there was the force majeure? Because somewhere along the line, there's going to be a cost impact there. And therefore, you also need to look at, particularly with the force majeure, what is the history? The local authority clearly stepped in, road authority, road agency, to create a temporary bridge, presumably, in the time that we're talking about. Was the contractor and the client party to that? Were they just told the day before it opened, oh, there's going to be a bridge here? What's the history? Because there's a question then of preparedness to get started again. So it would be a question for me of dealing with those facts such that the engineering deliverable issue, the force majeure issue, and the prevention of site are put into context based upon what was planned, what actually happened, and then we've got a basis to start analysing impact and demonstrating time and entitlement. But until you get to those facts, you're a little bit stuck in knowing what the real picture is. So if we think about that, then what contractual terms, in contractual terms, should the contractor do? What he's got to comply with the contract faced with those facts.
Yeah, absolutely. I think first and foremost, if it hasn't done so already, and assuming it is still within the time limit specified in the contract, then the contractor has to ensure it's given the appropriate notices that are necessary to secure an entitlement to claim extension of time and probably also money. As a sort of recap, where a contract sets out conditions precedent to extension of time entitlements, then those conditions must be complied with. We discussed this in the second webinar, and failure by the contractor to comply with the contractual notice provisions can and probably will mean that entitlements are waived and therefore lost. The courts have been quite strict about these things, that conditions precedent are exactly that, and if you fail, then you fail. So there's very little leeway if you haven't given the right notice on time to somehow suggest that because your claim has merit, it should be nonetheless considered. The processes and the procedures in the contract are there for a reason, and they have to be complied with. So the contractor should ensure that it submits a notice of claim if one is required. It should ensure that it submits the claim for the extension of time and the claim for any additional payment within any limits for doing so. The claim should be made in accordance with the requirements of the contract. If the contract says provide substantiation, then it should be provided. And remember some of the tips we gave in the first webinar in relation to making credible and realistic claims. Those should be followed at this stage. Don't make a bad claim now, because it's very hard to support a bad claim later on. You're far better off making a good and realistic claim now with the abilities to substantiate it. So I'm just going to recap a few of the points that we discussed in the first webinar, and which would be my recommendations to the contractor in terms of setting out its claim. So remember, a claim is a demand for something which is due. This was the definition that we mentioned to begin with. The contractor needs to produce a written claim to demonstrate that the event occurred, it caused a loss, and it's entitled to be compensated under the contract for the loss. That's got three components. One is the event occurred, two is the loss that was caused, and three is the entitlement to compensation. If one of those components is missing, then the claim isn't going to work. It will fail. Causation is the most difficult element in legal terms, and I think the work required to establish causation should never be underestimated. It's not enough just to show that the event occurred and or that the loss was incurred. Showing what links them together is key, and that's critical to the success of the claim. So claims must show cause and effect. Making the demand is easy, but showing that something is due is more difficult. And that's where you need cause and effect. A claim is not a claim without cause and effect. So that would be my starting point. John, practically, to avoid an awful dispute over this, what are the contractor's options? And in addition to preserving its contractual rights, what should the contractor do to resolve it?
Well, I think this is a classic situation where this issue needs dealing with at the time that it occurs. There's a narrow window of opportunity to re-baseline the schedule and re-baseline the project, because there's a schedule issue and probably a price issue. And if you don't, then very early on in the project, you've lost the basic control mechanisms for the project, and it'll be out of control. So as I mentioned earlier, the contractor can jump in and say, oh, we'll recover the delay. Well, the client's going to be very happy about that, because he's off the hook for anything. But the contractor will find it progressively more difficult to control this project because it's not been properly regulated. And he may struggle through and be successful, but the chances are he won't. One thing's for certain, and it applies to both parties: if you allow a situation like this to go unresolved for any length of time, the potential for dispute increases dramatically. Forget the practical parts about it, of control and management, and that's one issue. But if this goes on, then positions harden and the chances of dispute increase dramatically, or the resolution of those issues becomes that much more difficult to negotiate, because then you've got other issues piling up, which always occur on projects, and it just makes the picture much more murky. So deal in any situation, not just a force majeure issue or non-access to the site. Any situation early on the job and through the job should be dealt with as and when. And in fact, that's what the Construction Law Society's protocol suggests that we do, and it's good advice. So I think the first thing is to determine will these circumstances cause critical delay, and if so, what is it? That gives you your baseline. That's what you've got to know first off, and you need that factual analysis to be able to get to that. I think the next thing is checking any intermediate milestones for impact. So is there anything that you should be achieving that's critical that's going to be prevented early on? Never mind the completion date. That could be a couple of 3 years away, but there's maybe some earlier obligations that need to be looked at. It doesn't say anything in the question, but I guess if it's a modern contract, there'll be an obligation to mitigate the effects. So you've got to take that in. What can we do to mitigate the effects here without incurring any contractor expense to be able to reduce this delay a little bit, if at all? You've mentioned notices about extension of time, absolutely. And to be able to particularize those, of course, you need the schedule analysis done to be able to quantify how much time we're talking about. And it's not good enough just to say, well, that's what we planned, and we're going to add a few days or weeks on, and that's our extension of time entitlement. It's got to be analysed, it's got to be demonstrated, and it's got to be a critical path issue. I think it's also, regardless of where you stand with the client on resolution, you've got to have a realistic schedule. And this ties into the mitigation issues as well. What can be achieved as a basis for going forward with the project? Regardless of the client saying, I'm not granting extensions of time, that's one thing. That's a contractual issue. There is a practical issue here, and that should tie in with what the assessment of the delay is as well. And in that context, I think you've got to press very hard for a discussion. This isn't a very difficult issue to deal with in reality. The two parties may be difficult to deal with each other, but the issues are not that difficult. I think if the client refuses, and it's really, if I'm sitting on the client side, I'd want to clear this up pretty quickly. I won't want it to drag on. It's not wise. I think we would say that, the contractor has demonstrated an entitlement to extension of time, and therefore you're obliged to award that. And there's no point in not awarding it. And if he doesn't, then be very clear. It's a breach of contract. And don't mess around with the words. It's what it is, and call it what it is. And request discussion to resolve the EOT, because we need a fixed completion date, and right now we don't have one. We need to regulate the contract. You can offer without prejudice discussions about acceleration. You grant me an extension of time that's properly due, and if you have a need to have this plant finished sooner, then that's okay, because we can look at that and agree what the terms are for achieving it. Because it might be in your interest, pay a bit more money, finish on time or earlier than what the extension of time will be. And you have to counter the argument from the client about not being delayed, not being obliged to award an extension of time because the contractor was already in delay. I mean, there's plenty of arguments that we can turn to on this basis and say, this is not a sustainable argument. Unless the contract is very clear to eliminate any entitlement as a result of these circumstances where the contractor is actually late, then that argument doesn't stand. It is incidentally one that I've heard from owners on more occasions than I care to remember. But that's usually born out of ignorance rather than anything else. So if the client's still insisting on no extension of time and finish on the original completion date, then I start talking about constructive acceleration. And I start saying, you're in breach. We've demonstrated entitlement to extension of time. You've not awarded it. We have a choice. We can either face delays and liquidated damages, or we can take measures. We're going to take measures and we're going to bill you for it and make it very clear what the situation is. Now, that doesn't solve the problem, but it preserves the position of the actions, the breaches of contract, and the actions you're taking in face of those breaches of contract. And if there still isn't a basis for negotiation face to face, then I propose some sort of ADR, whether that's mediation or whatever. And if they refuse that, all these are steps which show the unreasonable behaviour of the other side. And that'll be very important in due course if this comes to a dispute. So that's my thoughts on it.
I think some great points there, John. Great strategic points that you know, the party would be well advised to consider those, because I think you know, they need to take control of the situation ultimately, and it won't be easy. You know, getting what you want is not easy a lot of the time, unfortunately. That was a great question. You know, thank you to the person that sent that. It was really thought-provoking, and obviously plenty of issues involved in it. I think we'll move on to another question, which was similar and gave rise to a few issues to discuss of a slightly different character. I'll just read the question out. So this one was about, again, an EOT clause, and it said the EOT clause in our lump sum turnkey EPC contract states we're entitled to extension of time due to change orders issued by the owner in accordance with the contract, force majeure, suspension by the owner in accordance with the contract, and change in the law. So quite a restricted set of EOT events there. The question adds that the contract is governed by Swiss law, but the project's not in Switzerland. The owner says that we are not to proceed with any work on certain drawings, Class A, until they're approved by the owner. The owner has 30 days in which to approve the documents. However, the owner took between 40 and 65 days from submission of the documents to giving approval. And in this period, he raised a lot of queries, but in the end, we didn't have to change any of our design on the drawings because the owner's points were cosmetic, such as font type and size, etc., which we amended very quickly and resubmitted the drawings to the owner. However, the owner insisted that the drawings had to be improved before we could go ahead with the work. This caused a big problem for us. We've requested an extension of time of 1 month, which we've assessed is the average delay to the work caused by the late approval, but the client has refused to grant it because he says that the EOT clause does not cover delayed approval, and therefore we took the risk in this respect. Again, the question is, what's your opinion and what action should we take? So I think, again, just to, I suppose, break it down a bit more for everybody, let's consider the issues. We have a contract that limits the grounds for extension of time claims to 4 specific events: change orders, force majeure, suspension, probably for non-payment, and change in the law. We've got a governing law issue about Swiss law. Swiss law governs the contract. Switzerland is a civil law jurisdiction, as are many continental European countries. So from a legal point of view, while an English qualified lawyer can advise on the contractual principles, they'd actually need to work with a Swiss lawyer to understand how the contract might be interpreted under Swiss law. And the contract requires certain drawings to be approved by the owner, without which the work cannot start, and the owner exceeded the contractual approval periods, which the contractor alleges caused some delay. So the contractor, again, is seeking an extension of time, which the employer, again, is refusing to grant. So I think, rather like we did in the first question, I would be looking for the following information. I would be looking for whether the contractor has an entitlement to extension of time in these circumstances, and if not, whether the employer's breached the contract, and if so, what's the effect of the breach. And I think the other thing that's a concern in this case is whether the Swiss law might change the position under the contract, or whether any of its civil laws may actually assist the contractor. Remember, civil law is codified law, so it's laws that are written down. You know, unlike English law, which is sort of constantly evolving, and it's subject to statute, case decisions, but also sometimes tradition and other things. So I think we would need specialist Swiss legal advice to answer this question, which we don't have on this webinar, unfortunately. So I'll say anything further with that caveat in mind. John, have you got any initial comments? Is there anything that you look to from a technical perspective here?
I think experience says that Swiss law, like many of the other civil code jurisdictions, relies heavily on documentation when you're in arbitration. rather than testimony. The dominance is documentation. Therefore, in this case, the analysis of documentation is absolutely fundamental. You still have to do it anyway under English law, but here, with Swiss law in particular, they will be looking at what is the documentary evidence, what does it tell us? And therefore, you need to review the approval process in great detail. And I just got to an aside, I just thought of something. A few years ago, I was asked to talk to an EPC contractor in the Far East about a power plant they were building, and they got some delays on. And we went to this meeting, and the project team were there, and they said, oh, we've got this massive delay, and it's all down to the client not approving our drawings on time. And they said, very similar to this job, it's 30 days approval period, and they didn't approve it in time. And we've got lots of drawings, and we're entitled to 18,000 days extension of time. 18,000 days. I had to get my calculator out to work out that was nearly 50 years. So I said, before we get into the delays, when do you actually expect to complete this thing? And they didn't really know, but it wasn't going to be 50 years. So I said, can you explain to me how you get to 18,000 days? So he said, yes. We've got X thousand drawings. They had to be approved within 30 days. The client didn't approve them within 30 days. It took X, Y, Z days. We totted up all the days that went over 30 days, and it comes to 18,000. And that's our extension of time. So we then started on an education process, which was, this doesn't quite work like this, folks. We have to look at where the client has a right or an obligation to review documents. We must look at what that review process entails, first of all, and what can he do and what can't he do. And if there's a classification of documents, and it's not unusual for documents to be classified, those that must be approved, those that have to be submitted for review and comment, and those that we're not actually interested in. Or whatever the classification is. So here we have a situation where it's mandatory to have the owner's approval of these documents. And that often occurs where you've got a project where the engineering, basic engineering is very sensitive to plant performance or whatever. So this is the name of the game. Now the question is, you have to look at why would the client, why would the owner want to review those documents, and what sort of contribution can those review and approval processes actually make to the reliability of the engineering? Because what we're looking at is, can we build the plant properly, and will it perform, and so on. And it's in everybody's interest, is that, let's not forget that. So then the question is, okay, what form does this approval take, in the sense of what is the client looking for? And I would suggest he's not looking for font style or font size, because it won't aid the achievement of the performance guarantees, which will inevitably be part of this contract. He's looking for things that are not engineering, or he should be, not engineering consistent to deliver the performance that's required. And it should be confined to that. So, and I've been involved in a lot of projects where this sort of question has arisen, so it's fairly common. I think the questioner was right on the ball with the problem. So what are the documents that are actually not in line with the requirements for engineering practice to deliver the plant? And if this is just a review of the pretty pictures on the drawings, then as a project manager, I'd want to be jumping on that pretty damn quick and saying, no, let's stop this, and just explain to the client that he's not aiding his own project here. Now, the problem that crops up in these situations is, so often the people that are reviewing those documents are not the owner's own people. They are hired hands. And for whatever reason, they think it's their role in life to pick up everything on the documents. And if they can't find anything technically interesting, then they'll find things that are not technically interesting if it's only to keep them in a job for a bit longer. I'm slightly cynical, but it's fairly true. So this is a project management issue. It's got nothing to do with law. It's got nothing to do with contracts. It's got nothing to do with engineering as such. It's got to do with how you manage the client and get a grip of this situation and give him the opportunity to stop doing what he's doing and actually help with the delivery of the project, and to make it pretty damn clear that if he doesn't, this is not going to go well and it's going to be expensive and he's going to be paying. So it's really an issue. It's really about the human behaviours here, about how the client and the contractor interact to solve a problem that neither of them are probably creating, and somebody else who's hired in to help is actually causing the problem, which is a frequent occurrence. So we have to look at the relationships here very much to solve the problem. If it's allowed to go on, it will mature into quite a mess. And that's the experience over many projects with these sort of situations. So, given all that, how do we deal with this under the contract then? Alex, over to you.
Yeah, thanks, thanks, John. Yeah, so the comments I make now are subject to the Swiss law point, which I referred to before. But it seems to me the contract, again, we haven't seen it, but it would be surprising if the contract wasn't clear that if the contractor doesn't have certain drawings approved by the owner, then the work may not proceed. That's in the question. It seems pretty clear that the owner has exceeded the 30-day approval cycle. And given that the contract says works may not proceed, it seems probable that any delay to the 30-day period has got at least potential to cause critical delay. It seems like there's an issue about whether the contract gives the contractor an extension of time for late approval by the owner of the drawings. At first sight, it doesn't, because that doesn't seem to fit within one of the 4 EOT events. But I think I wouldn't rule it out at this stage. I think close analysis of those provisions is required to see whether the drafting of the contract is sufficiently wide to cover late approval. I mean, that sounds a bit strange, but this is all about the wording and what can be fitted in. You know, how much wiggle room is there in these clauses? You know, how's it defining a change order? How wide is the definition of force majeure? I recall a contract where a change order was very wide and could include a great many things, many of which weren't actual changes to the scope of works, but it could have included other things. So all is not lost yet on the contract. We'd have to have a look at it properly. I think if, as is likely, the contract doesn't allow for those EOT events to get within the definitions, I think my view is that the effect of the owner's delayed approval needs to be considered quite carefully, because if approval is required within 30 days in order for the works to proceed, then any delay that's caused by the owner beyond the 30 days seems to be a breach of contract. And as such, it has potential to cause critical delay. So I think if the owner is trying to hold the contractor to the original completion date, then there's no entitlement to extension of time, and there's no entitlement to extension of time, then that seems to engage the prevention principle that we talked about in the second webinar. Just to recap that, if the owner prevents the contractor from proceeding with the works by exceeding the review period in this case, and if there's no provision that allows a new completion date to be fixed, then time is said to be at large. So the owner can't, on one hand, prevent the contractor from proceeding with the works by not approving the drawings, and on the other hand, insist that the contractor achieves the original completion date. So the effect of that is that the contractor is relieved from completing the works by the original completion date and instead has to complete the works within a reasonable time. That's the prevention principle. So in this case, I think there's probably a time at large argument, which are generally quite difficult arguments. The contract should, as a minimum, I think we said this before, allow for extension of time if there's an act of prevention, and certainly where there's change orders. I mean, if they don't, then they risk putting time at large. I think it's also worth mentioning here the choice of law. The choice of law governing a contract can have very significant implications on the contract that the parties are agreed and signed up to. Often, I think the implications can be quite unexpected if the party doesn't understand the law it's signed up to. That sounds silly, but it does happen. I've seen several cases where parties have chosen a governing law that they weren't familiar with that affected how the contract might be interpreted and applied. And I think in these cross-border international engineering and construction contracts, parties should be quite careful that unless there's a really good reason to do so, they should choose the law that they're familiar with, which is likely to be the country in which they're based or where the project is based perhaps, and really never choose another law without taking advice on the interpretation of the contract under that law. Because despite what the contract says, the law can have quite a significant implication on what the contract says. I give an example. Under English law, if you've agreed liquidated damages apply in a contract, then if the circumstances in which those damages are payable, so a delay or perhaps performance, they're payable. There's no question of challenging it. They've already been agreed. Whereas if the contract is under, say, the Qatar Civil Code, the same principle doesn't apply. So under that law, liquidated damages can in fact be reduced by a court to a sum that better reflects the actual loss. So they're not set in stone as they are under English law. And it's important to understand that different jurisdictions treat things differently, and don't just go for a law that you don't understand. So John, what's your take on the question, and what do you think in practical terms should the contractor do to resolve this?
I think that the contractor is faced with a bit of a dilemma. The engineering process is iterative. So you don't just produce a set of deliverables and that's it. Those deliverables go through a revision process. And while those different deliverables may be classified in whatever way, the ABC or whatever it is, the engineering process is not geared up to a stop-start arrangement. It can be massively disruptive. So whilst the contract and the drafters of the contract in their wisdom decided that it was mandatory for the client to approve these particular documents, they weren't actually recognizing that that's extremely difficult in the engineering process, particularly in an EPC contract arrangement when we're into that phase of engineering. So while the contract may say that, and the contractor, for the benefit of his claim at the moment, may be asserting that, the reality is probably, and in my experience, it's what happens, is that the contractor doesn't stop. He can't, because it's going to screw his engineering team terribly. So we have a situation where we have a lovely, straightforward, clean legal position that is rather spoiled by the practicalities of life. And I think that that is where there comes some difficulty, in addition to the ones that you were talking about under the contract, as to, you know, how do you deal with this, and is it time at large, and whatever legalistic position may occur. Because at the end of the day, let's assume you as the lawyer find a way with your your Swiss counterpart to a legal solution, you will be relying on the practicalities of life and the actual facts, which may be 180 degrees away from what the contract anticipates. And that will pose you another legal problem. And, you know, I was dealing with one of these situations not long ago where the contractor was trying to tell me that the client's delayed approval, not non-approval, but the delayed approval of P&IDs was causing a critical delay to the project. And the delay analyst had shown by playing with the P6 that indeed there was a critical delay. It's complete garbage, because when we dug down to analyze what actually happened, so I asked him, what engineering deliverables did you stop producing? And the short answer to that was none. We didn't stop the process. And therefore, the extension of time claim based on later client approval evaporated like steam on a hot plate. So it's, you know, every time we have to get back to the practicalities. What actually happened? Because otherwise, you start going into the world of theory, and nobody's going to believe it. you just get lost. And you can come up with all the sort of contractual legal arguments that you like. If the facts don't support it, it's not there. Now, I might have burst your legal bubble there, Alex, and I'm sorry, but it's nearly the end anyway, so it doesn't really matter.
No, I mean, you're definitely right. You know, the idea, we've said this before on these sessions, really, the idea that you could employ some experts, and I suppose employ lawyers as well, to kind of work their magic on a problem, you know, is true to a point, I guess, but ultimately it's the facts that, you know, the facts are the facts, and they are what win and lose cases, I think. You know, sometimes cases are won and lost on legal points, legal arguments, but ultimately it comes down to what actually happened. And who's right. You know, the facts are either on your side or they're not, and it's always difficult when they're not, but when they are, I think things generally look pretty good, look better. That, I thought that was another great question as well, so, you know, thanks for asking it. And it's been nice to go into detail in those two questions that we've done. We haven't had any questions from the people watching, so that's either been that what we're saying is very interesting, or yeah, we certainly haven't lost any people either, which is good. So, you know, thanks for staying with us. I think we've obviously wrapped up on the psychology of claims now. I think maybe we've got probably 1 or 2 minutes where we'll just give our final thoughts. And I suppose for me, I think what this shows is we've said a few times how on these projects the issues are caused quite early on generally. You know, design issues tend to be quite prevalent, and engineering problems tend to be quite prevalent, but it's when you get into construction that these things tend to be felt. And I think both John and we've discussed how maybe parties need to be a bit more, I would say hard-nosed, but a bit more rigorous in terms of the contract at the outset, and not, you know, leaving things to drift. John, do you think there's a reason why that happens?
I think there's two well-established myths about this. One is that the client will be desperately upset if you raise these issues with them early on, particularly during the contract honeymoon period where everybody's very happy with each other. I think that's a true myth, because if you actually are confronted with a problem that needs resolving, it's not going to improve with age. And the earlier you can get that to the client and have an adult conversation together about that problem and its resolution, the better for the project. And it might be tough, but in my experience, it's far preferable. And the other myth is, and this comes from the owner's side, that the contractors are only interested in making money on projects. Well, it's true. Contractors are commercial organizations in the main, and their aim is to make money. But when you look at their trading results in these days, they're not that successful at it. And my experience of, particularly in the engineering construction business, the contractors are more interested in delivering good projects, and particularly their project managers. And they're not that focused on actually generating situations to create more income. There should be, because I think there's some entitlement there, but typically it's not. So the industry sort of is operating against two myths, which don't help. And therefore, I think some adult conversations about real issues, not theoretical issues, to solve them for the benefit of both parties is the way to go. And therefore, sometimes you need some tough conversations. There's no doubt about it.
Yeah, I agree with that. 30 seconds, John. We've had a question pop in, I think, as a sort of follow-up to that second question that we discussed. Would the owner have to declare the drawings as defective to have a ground to resist the EOT? What's your snap verdict on that?
I think the issue in this question is not about whether the drawings are good or bad, but whether the client took the time, he mandatorily took the time to review them. And I think going to the question is, there would have to be, his reasoning for taking that time would have to be that there was something wrong with the drawings. Now, that wouldn't necessarily give you a right to extension of time. What that would do is say there's something wrong with the drawings and you'd have to fix it. So I think that the real issue is here, he was consuming time for no beneficial reason, and that's the wrong thing. If he was consuming time because the contractor got the drawings wrong, then that's his right and his obligation to do, and then the contractor's got to fix it. And I think that's the situation. What's your view?
Yeah, I agree with that. I think there's nothing in the question, that suggests that there's sort of fundamental problem with the drawings. And I think if you're looking at the contract quite strictly, I think what's happening here is, as you alluded to earlier, it's a sort of mischievous, for whatever reason, we're going to be pedantic about font sizes and things like that. And I've certainly seen that before. To me, that's not a good enough reason to reject drawings under most contracts. So that's simply going to create issues, I think. So I agree with what you said, and I think we're almost at the end of our time. So thanks for the questions. I'm just going to take a few seconds to tell you about what we have planned for early next year, early 2021. We're at the end of the Psychology of Claims series, but we're planning some more webinars, and we're looking in particular at time and money claims, as it seems to have generated so much interest. We're planning to run a workshop over 2 sessions, which will be in early 2021 at some point. We haven't quite yet confirmed the date. We're going to look at a case study, and we'll have the delegates or attendees review the case study and work with us as coaches to look at the issues that are going on in a typical delay, extension of time and money claim scenario. And we'll have the workshop in 2 parts. So the first part, we'll consider the case study and the implications. We'll split everybody up into work groups. So some groups will consider the owner's position, some will consider the contractor's position, and John and myself and some others will be coaching those teams on what to do. And then in the second workshop, we'll consider what you have to do to prepare for litigation or arbitration, and we'll look at the experience of giving evidence in court as a factual witness. And we've got one of London's top construction barristers available to conduct a mock cross-examination of one of our attendees, if you so wish. And this could be valuable experience. It's certainly something that doesn't happen outside of a courtroom or a hearing. It could be really very interesting. So I think if you're interested in that, we'll have maybe 20 to 30 places available. We'll charge €95 per person per event, and it's really suitable, I think, probably for senior project managers and senior people who are on site on the project, who might be called upon to give evidence because they are the person that sits at the heart of the job and knows all about it. So if you're in that role, or you know someone who's in that role, this could be really good training for them. Unlike the free series that we've done, this won't be publicly available. So if you'd like the details about it, we're inviting expressions of interest. So please just let us know if it's something that you'd like to do. And I think other than that, many thanks for joining us over the course of our series. Thank you for the questions for today, and thank you for the support. And hopefully we will see you again soon. Thank you very much.
Yeah, keep safe, everybody. All the best. Bye.
Thanks.